Welcome to video 3 of the 3-video installment on proximate cause. Video 1 introduced the restatement third of torts, section 29, as the rule of law that is applied to determine or to establish proximate cause. The second video introduced the restatement third of torts, section 24, which is the rule of law that is applied when we are trying to establish proximate cause when there is an intervening act. This video, video 3, is the third of the video installment for proximate cause. And in this video, we're going to apply the restatement third of torts, section 34, to 2 additional cases to make sure that you're comfortable with the application of the doctrine. And then we're going to take a look at criminal acts that do break the causal link for proximate cause and criminal acts that do not break the causal link for proximate cause. And we're going to be introduced to the rescue doctrine. So with that, let's jump in. We're going to go ahead and go to our third case. That's Doe v. Mannheimer. Since we introduced the 4-step algorithm for proximate cause under the restatement third of torts, section 34, when we are addressing intervening causes in video 2, let's go and continue with that energy and review the case of Doe v. Mannheimer. So what are the facts that we need to know in this case? We have a property owner by the name of Mannheimer who owned a piece of property in New Haven, Connecticut. The property bordered a public sidewalk and roadway that's used by pedestrians. Over time, the property became severely overgrown with dense vegetation, and the vegetation had grown so much that it was several feet high, creating a pretty thick area of concealment that was next to the sidewalk. Now, the homeowner had received some complaints from neighbors about this overgrown bush, right? The complaints included descriptions of the vegetation being as dense enough to allow someone to hide within it. Now, if that's hyperbolic or actual, we don't know. We don't have those facts. But we do know that the property was located in an urban neighborhood where there was quite a bit of pedestrian traffic, right? So it was normal, it was regular to see pedestrians walking up and down the sidewalk. The plaintiff is being identified in the case as Jane Doe. Jane Doe was walking on the sidewalk next to the property. As she walked past the overgrown area, a man jumped out, emerged from the brush, dragged the plaintiff into the vegetation, and began to assault her. Miss Doe suffered severe physical and psychological trauma as a result. So here's the question. Miss Doe sues Mannheimer, the homeowner, alleging that Mannheimer's negligence led to a creation of a condition that ultimately caused her harm. And the question that we have to ask is the intervention, right? The intervention by the third party. Did that act stop the proximate causal link from the negligent act of the overgrown vegetation and the harm of Miss Doe? Well, we know that we have a 4-step algorithm, so let's set it up. Step 1, identify the original negligent risk. What was the original negligent act? The act was failing to maintain the vegetation and allowing it to get to a state of overgrowth. Okay. What are the risks associated with that? The risk associated with that, as found by the court, was reduced visibility, concealment of conditions, general property maintenance hazards, right? We've got some reduced property value. We've got, we've all walked down a sidewalk or two in our life where the branches of the tree is hanging too low and you run to the branch or almost get poked in the eye or you get scratched as you try to walk by. So there's some risk of some general minor physical injury, but the category of harms that are foreseeable are property harms, right? It's from a property perspective, probably ugly, right? It's probably the sore house, that one house that you, right, that always has the overgrown yard, unkempt. Yeah. But these are property damage harms. Yeah. Step number 2, identify the intervening act. What event or actor intervened between the defendant's negligence and the plaintiff's injury? Well, that was the criminal assault by the third party. Step 3, identify the harm that occurred. The harm that occurred was severe bodily injury, not a scratch from a tree branch, right? Not a poke in the eye from a limb that's hanging too low, but severe bodily injury in the sexual assault. Step 4, compare the risk that occurred, that's the severe bodily injury from the sexual assault, psychological as well from the sexual assault, to the risk that made the negligent act dangerous in the first place. So, is there an alignment? We have a severe sexual assault, and we have the risk of letting your vegetation grow to the point of it's now encroaching upon the public sidewalk. Do we have an alignment in the risk and the harm? The court said no. The court, in its explanation of their application of the rule, said the harm anticipated, if bodily, was not severe. Again, it's the poke in the eye from the branches or the scratch on the arm. The risk did not reasonably foresee some criminal minded individual intending to take out an intentional act because the opportunity presented itself. I stop there so that you can try to get a sense of how the rule of law is applied. Even if you don't agree with the outcome, you understand you're not supposed to make the determination of what the ruling should be and then back into the explanation. You're supposed to apply the rules. And when the court in its rather detailed explanation explained that this criminal activity was not foreseen as one of the risk, and as such, right, as such, the causal link between the negligent act of allowing your vegetation to overgrow and the actual harm that was suffered by Miss Doe was broken. The result, liability stopped. The intervening criminal act was treated as superseding because the harm was not considered a realization of the risk that was created by the property condition. Foreseeability in proximate cause cases attaches to the type of harm that results from the risk, right? Foreseeability is not asking about the specific sequence of events, it is asking about the general category of harm. Get it? Thus, the law focuses on the type of harm, not on the manner of the occurrence. So, the alleged negligence was the failure to maintain the vegetation. The plaintiff argued that the dense brush, the high weeds near the sidewalk, did create a concealment that was so effective that it enabled a criminal to hide an attacker. While the court accepted that the property was overgrown, and that was the result of negligence on behalf of the defendant, the court did not accept that being framed as a risk created by the condition, right? The court said that the harm that was suffered by Miss Doe was different than the harm that was established as foreseeable. When you're looking at intervening causes, be mindful, look at the kinds of harms that are typically associated with the negligent behavior and those risks. That is the Mannheimer case. Okay, so let's move on to Yoon v. Ford. What is Yoon v. Ford? The reason that I wanted you to read Yoon v. Ford was this. Again, I said it in video 2. I'll say it here in video 3. It's really important that you don't get set in your mind once you identify an intervening cause, you allow your mind to immediately establish a break in the causation. And Yoon v. Ford is the case that says it's not automatic that proximate cause ends just because there's an intervening factor. It is not automatic that proximate cause ends just because there's an intervening factor. What's going on in Yoon? In Yoon, we have the plaintiff, which is the estate of Jong Yoon, right? It's the estate of Jong Yoon because Mr. Yoon is deceased. Who's the defendant? The defendant is the Ford Motor Company. Here's what the plaintiff alleges. The plaintiff alleges that the Ford Motor Company put into the stream of commerce a vehicle that was defective. The claim was a products liability claim. What's going on? The wheel assembly on the Ford vehicle that Mr. Yoon purchased and drove was defective. How so? The way that it was either designed and or manufactured, the defect caused the wheel to detach. Well, What's the problem with that negligence? The problem is upon detaching, it's detached, right? So detached means it's no longer attached to the car. So what happens to the wheel? Well, it can roll into the roadway. It can cause a block in the roadway. It could create a road hazard right in the roadway. And so it's a big deal. Yeah. Let's go deeper into the facts. The vehicle involved was a Ford van, and it was owned and driven by Mr. Yoon. The van had a wheel assembly defect that caused the wheel and the tire to detach while it was being driven. Wow. The alleged defect was related to the wheel mounting system. Okay, here we go. We're on the highway. Mr. Yoon is driving on a multi lane highway, normal traffic. While traveling at normal highway speed, the wheel suddenly detaches from the vehicle. The detached wheel rolled away from the vehicle into the roadway. What else do we know? We know that Mr. Young's immediate response was to bring the car to a safe stop along the shoulder of the highway, which he did. The next thing that Mr. Young did, and he's deceased, so we don't get his perspective in this. But the next thing that he did after stopping the vehicle, he gets out of the van and he attempts to retrieve the detached wheel from the roadway, right? Maybe he's trying to prevent other motorists from having a problem. We don't know. We don't know. All of that is speculation. All we know is that he tried to retrieve the detached wheel. In trying to retrieve the detached wheel, Mr. Yoon was hit by another driver and he died as a result of those injuries. So here's the question. Ford Motor Vehicle created the original risk. What are the potential risks from selling, introducing a defective product into the stream of commerce? So, what risk made Ford's conduct negligent in the first place? Well, if we have a wheel that detaches, what are some of the anticipated risks? The wheel becomes roadway hazard. We have traffic accidents. People are going to try to enter the roadway to get the wheel out of the roadway. There's going to be injuries from passing vehicles, right? All of these risks are foreseeable. Step two, what is the intervening act? What event or actor intervened between the defendant's negligence and the plaintiff's injury? What's the intervening act? Mr. Young was the intervening act. Young exited the vehicle and tried to retrieve the wheel from the highway. Step three, identify the harm that occurred, bodily injury, because he was struck by another car and he died as a result of those injuries. Step four, compare the risk of harm to the actual injury. Did the intervening act produce the very harm that made the defect negligent? What do you think? The New Jersey Supreme Court refused to treat Young's conduct as superseding. What does that mean? That means that the New Jersey Supreme Court refused to say that the causal link between Ford's negligent product and the death of Mr. Yoon is not automatically broken because Mr. Yoon went into the road to retrieve the wheel. There is no automatic superseding just because there is a intervening event. That's why I wanted you to read Yoon v. Ford Motor Company. Get it? You have to go through the 4-step algorithm to determine whether or not proximate cause continues or whether or not proximate cause stops. Okay? Let's transition to criminal acts as intervening causes. As we've seen thus far, intervening acts do not automatically terminate proximate cause. They do not automatically terminate liability. The law does not simply ask whether another actor has intervened. Instead, the question remains the same, right? The question remains the same. Did the intervening act introduce a new and different danger, or did it merely bring about the risk created by the defendant's negligence? I'll give you 2 illustrations of criminal acts. Illustration 1. This illustration shows the criminal act terminating liability, right? Breaking the proximate cause chain. Here it is. A homeowner negligently leaves a ladder leaning against the side of the house. Later that night, a burglar uses the ladder to climb to a second-story window, break into the home. While fleeing the burglary, the burglar attacks a pedestrian on the street. The pedestrian sues the homeowner, arguing that the ladder made the crime possible. The ladder made the crime possible. What does it sound like? This sounds like Mannheimer, where the plaintiff's argument that the overgrown vegetation made, right, made the crime possible. Remember, in Mannheimer, the court said, look, there's a difference in a third party using an opportunity to commit a crime and the negligence making the crime possible, right? There's a difference. So let's apply the factors. What's my step 1? Do you remember them? Did you write them down? Let's go back to Hines, or we can go back to, let's go back to Yoon. Step 1, identify the negligent risk. Let's go back to our fact pattern. What is the negligent risk in the homeowner leaving the ladder leaning against the side of the house? What's the negligent risk? That the ladder falls and hurts somebody, right? So we've got some bodily injury. What? That the ladder falls and creates some property damage. Let's say the ladder's tall enough, it falls over the privacy fence and breaks something in the neighbor's yard. So we've got some property damage and we've got some bodily injury from this falling ladder. Yeah. Number 2, what's the intervening event? The intervening event in this scenario is the burglar. The burglar using the ladder, the burglar jumps down or jumps on the ladder, jumps in the house, runs out of the house, and knocks over party C, this pedestrian, right? What's number 3? Number 1 was, what was the original risk? Number 2 was, what was the intervening act? Number 3 was what? What's the actual harm? The actual harm is that the burglar attacks a pedestrian. That's the actual harm, right? Is attacking a pedestrian, is that risk one of the risks that made leaving the ladder aside the house negligent to begin with? The answer is no, right? The answer is no. My house, my ladder, I leave the ladder up against the house. Is that safe? Right. Is it negligent? Yeah, right. Take the ladder down, put it up, just put it up the next day. I'm too lazy, I'm too tired, I don't want to do that. So, yeah, there's some negligence in leaving that ladder extended up against the house. Is the risk of a burglar coming, breaking into the house, running out of the house, attacking a pedestrian one of the foreseeable risks? No. Got it? Because that is a different risk. That's something new and different that's been introduced. The proximate causation, the proximate cause link for the homeowner is broken by the acts of the criminal activity. Get it? Illustration number 2, criminal act does not terminate liability. This one, the criminal act does terminate liability. The second one, the criminal act does not terminate liability. What do we have? We've got a shopping mall that negligently fails to provide adequate lighting or security in a parking garage, despite repeated reports of prior robberies. We've got a customer who walks through the garage at night. An attacker emerges from a dark area of the garage and commits a robbery and assault. The victim sues the mall owner for negligence. Ready? Let's apply it. When we apply it, what do we get? What's my step 1? What is the original negligence? What is the original negligence? Well, the original negligence is what? Failing, right, to provide adequate light. So, what risk made the defendant's conduct negligent in the first place? Failure to provide adequate lighting. If I'm in a shopping mall and I fail to provide adequate lighting, what kind of risk am I looking at? That customers are going to get robbed, customers are going to get assaulted, other criminal activity, right? That's the risk that I can foreseeably anticipate. What's step 2? Step 2 in this case is the intervening act. What's the intervening act? I've got a third party that comes in and commits criminal robbery. That's the intervening act. What's step 3? Identify the harm. The harm is bodily injury resulting from the criminal assault. What's step 4? Are they aligned? Did the intervening act produce the very harm that made the defendant's conduct negligent in the first place? The answer is yes, right? The risk created by negligent security was precisely, right, provided risk of criminal attack. We've got alignment, which means that the proximate causal link is not broken because the harm falls within the scope of the risk created by the negligent security. The intervening criminal act does not terminate liability. Liability continues. Get it? Here is another predictable human response to danger, and this is the last doctrine that we will address under the topic of proximate cause. This is the rescue doctrine. One category of intervening conduct that courts treat with remarkable consistency is rescue. The rescue doctrine reflects a very simple principle. danger invites rescue. When a defendant's negligence places someone in peril, it is entirely foreseeable that another person may attempt to help, right? Because rescue is a natural and predictable human response to danger. The law treats injuries to rescuers as injuries that fall within the scope of the risk created by the defendant's negligence. For that reason, the rescuer's intervention will not break the chain of liability. The rescuer's intervention will not break the proximate cause chain. Get it? The rescue doctrine operates within the third restatement, section 34, because there is an intervening act. What's the intervening act? The rescue, right? What's the intervening act? The rescue. And so if we have a negligent act, one of the risks that we can always presume is going to be a rescue if it's appropriate. Here's an example. A driver negligently runs a red light and crashes into another vehicle. The collision leaves one car overturned with the driver trapped inside. A bystander runs into the roadway to help pull the injured driver from the wreckage. While attempting the rescue, the bystander is struck by a passing vehicle, suffers serious injury. Bystander sues driver. Step 1, identify the risk. What's the risk? Running the red light. Or what's the negligent behavior? Running the red light. What's the risk of running the red light? Collisions, property damage, bodily injury, roadway emergencies. Add this one, always an attempted rescue. An attempted rescue. What's step 2? Identify the intervening act, the rescue, right? That's the intervening act. That's the thing that happens after the negligence. That's the thing that happens after the negligence, right? And it's after the negligence and before the rescuer's injury, right? The bystander wasn't injured until the bystander tried the rescue. So it's after the defendant's actions, but before the rescuer's injury. So get it? It's the rescuer's injury. 3, identify the harm that actually occurred. Well, what's the harm that actually occurred? In my scenario, the bodily injury to the rescuer after being struck by another car while attempting the rescue. Step 4, is there alignment? Did the intervening act, that's the rescue, produce the very harm that made the defendant's conduct? Absolutely. It's not a different harm. It's the harm to the rescue, which is anticipated, because danger, here's your opportunity to fill in the blank. Danger invites rescue. Because the rescuer's injury results from the very danger created by the defendant's negligence. That intervening act of the rescuer does not terminate liability. Liability therefore continues, which means that proximate cause is established. That is the end of proximate cause. We now move to damages. Hopefully this was helpful, and I'll see you with the next series of videos.